I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series discussing Sections 16 and 13 of the Securities Exchange Act related to insider reporting requirements. Today, I am continuing my discussion of Section 13 and in particular Schedule 13G. In prior LawCasts, I've discussed Schedule 13D. Section 13 requires that any person who has acquired, either directly or indirectly, more than 5% of the beneficial ownership of a reporting company's securities to file either a Schedule 13D or 13G within 10 days of the acquisition. The disclosure includes, among other things, the identity of the beneficial owners, the amount of beneficial ownership, and plans or proposals related to the company. A Schedule 13G is a shorter and simpler form than the Schedule 13D. It has less questions, less information is required. Schedule 13G eligible filers include qualified institutional investors, passive investors, and exempt investors. A qualified institutional investor is an investor that has acquired the securities in the ordinary course of business without the purpose of influencing, control, or affecting a change of the company. Examples of institutional investors include registered broker-dealers, registered investment advisors, and registered investment companies. Shareholders who are passive investors can also file the simpler Schedule 13G as opposed to the more burdensome Schedule 13D. A passive investor cannot be an investor that owns 20% or more of a class of securities. So if you own 20% or more, you're not a passive investor. Moreover, a person that is in a control position, such as an officer or director, cannot be a passive investor and cannot file the shorter Schedule 13G. A Schedule 13G filer must file the schedule within 10 days of the end of the month of the triggering event requiring the filing, and they must file an amended Schedule 13G within 45 days of the end of the calendar, not fiscal, but calendar year, to report any changes in beneficial ownership. Also, if the Schedule 13G shareholder acquires in excess of 10% of the company's stock, they have to file an amended Schedule 13G within 10 days of that acquisition. And also, they have to file an amendment within 10 days to report increases or decreases of more than 5%. So an amendment would have to be filed either within 45 days of the year end, if you acquire more than 10% of the outstanding securities, or there's a change in ownership of 5% or more. A Schedule 13G filer that has a change that triggers a Schedule 13D, such as a change in their intent related to the issuer to influence control or participation in control of the issuer, they must file a Schedule 13D within 10 days of that change. Only security holders that were once a Schedule 13G filer and changed to 13D can go back to 13G. If you're a Schedule 13D filer, you can never change to 13G. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.